Hi, I'm Karlene Salmon. I'm your sister-in-law, and today we're going to talk about recovery of possession when you are a landlord with a tenant who you need to get out of your property. So now, on the last occasion, we talked about a situation where you have a squatter in your property and the steps you take to remove the squatter. So now, what if it's not a squatter? What if you have a tenant who is not paying their rent or who has breached the covenants of your lease? Like, say for example, you have rented the property as a residential property, as a house, and they have converted it into a shop. No, that breaches the covenants of the lease, but it also could breach the covenants of your property as well. There might be a covenant on your title that says no shop, church, or school should be on the property. And yet, this person has opened a shop, or opened a school, a basic school, or opened a church in your residential house. So those are examples of breaches of contract, not paying rent and breaching the covenants of the lease or the covenants of your title, getting you into trouble. These are grounds on which you can give a tenant notice to leave. All right? So here's the thing, unlike with a squatter, the notice takes immediate effect. You can say, look, Mr. or Mrs. Squatter who is living in my property, free, whatever, I'm hereby give you notice to come off with immediate effect. With a tenant, it's a little bit different. You have to give a tenant 30 clear days of notice to leave. So, and that is 30 days looking at when the rent is due. So if the rent is due, for example, on the 1st of April, it means that you have to give them a notice on or before the 1st of March, giving them 30 days, 30 clear days. In fact, you're giving them 31 if you're giving them notice on the 1st of March. But the law says you have to give them 30 clear days before the next rent is due of notice to quit. So you give the notice on the 1st of March for them to come out by the 31st of March, on or before the 31st of March. That's 30 clear days before their next rent is due. All right. So now you have some tenants who are very, very slippery. They are versed in the art of avoiding notice. It's as if it's like you know those people who say, I feel like it's going to rain because I feel like pains in their joints. There are tenants who have that kind of radar and know when the landlord is going to attempt to serve them notice, and so they disappear. They cannot be found. But there is a solution for that. All you have to do is take that notice and tape it up on the door of the premises that they have to go through, because the law provides that, and this is common law, not written in anywhere in statute, but the fact that the notice is placed in an obvious place that the tenant has to see, unless they're going to climb through a window, which is not really how people access houses or properties, right? They'd have to go through a door, the main door. So tape it up on the door, take a picture with your phone of the notice on the door, and that is your evidence that the notice has been served. Also make sure that you write on the notice the date it was served, the time, and who served it, because that you will be able to use when you take the next step, which we'll talk about right after this. We just finished talking about how you can serve your tenant who either they're not paying their rent, or they've breached some covenant of the lease or some covenant of your title, for example, by having a school or a shop on a premises that is really just supposed to be for residential purposes only. So you want to get rid of them. So we've talked about the ways that you can serve them. You can serve them personally, the notice to quit personally, or you can tape it up on the door. Having served them notice, and they still don't come out, the time has passed, they've not paid their rent, they've not come out of the property, you can then go to court and apply for an order of recovery of possession. Usually this is the parish court that you go to, because the rent is usually unless it's a very, very expensive property, usually the rent doesn't rise to the $3 million threshold that the Supreme Court will require. So it's a parish court matter. So you go to the parish court, you get a summons, and a date for the tenant to come to court, and both of you attend and you present your case, including your copy of the notice that was served on the individual. And at that time, the judge will hear the parties, hear your side of the story, hear the tenant side of the story. Here's the thing, however, if the tenant pays the rent before the summons is issued, more than likely, if the tenant pays the rent, it cancels the notice to quit if they pay up all their arrears. If, however, they don't pay up all their arrears and they don't satisfy the court that they are in a position to or will be able to, the court will issue an order for recovery of possession and require the tenant to leave by X date.